Dear friends, now today we are going to discuss a very important issue which is rocking the nation as a whole. The three farm laws which have brought in, according to the government, revolutionary changes in the farming sector is creating ruckus in the country as a whole. So, what in fact these laws are meant to be for? That many of the people do not know, but at the same time, some kinds of factoids are going on in the country as a whole. Semi facts, semi truth, semi false assertions, all these are rocking the country as a whole. So, let us examine what are these laws actually meant for and the contents of the laws and how it is going to affect the future of the nation and also the future of the farmers. The first of these bills is something that is ensuring free trade to the farmers for their produce. We all know that there is a fundamental right that is guaranteed under the Constitution for a free trade. But so far, the farmers are not getting the benefit or the right that is guaranteed under the fundamental rights chapter of our Constitution. The farmers, when we analyze the APMC laws, that is agriculture produce marketing laws prevalent in many of the states, we see that the farmers' right of free trade of their produce is prohibited. Under the APMC laws, the farmer is not having the freedom to sell his produce outside the APMC markets. In many of the APMC laws prevailing in many of the states, there are schedules attached to the act which enlist the farm producers, in respect of which the farmers have not been given absolute right of trade in their produce. If an apple is grown or reared, the apple farmer is not getting the right to sell his produce to persons of his choice. If the APMC law is prevailing in that particular state, he is required to sell this apple only in the APMC. So he cannot search for better prices or better avenues for getting increased price for his produce. So this is something that is a big problem which the farmers of the country have been facing for quite a long time. I would say that since independence. So this has to be brought to an end. The farmer who is producing the farm produce must be given the full freedom and liberty to sell his produce to persons of his choice who are offering his better price. The APMCs, as I said earlier, even though are offering the minimum support price, the minimum support price is being taken away by the intermediaries who are standing in between the farmer and the APMCs. So this has to be brought to an end. So with this award object in mind, the legislature has passed the bill that's the Farmers Produce Trade and Commerce Promotion and Facilitation Act 2020, which I would, for brevity, call it as Farmers Freedom of Trade Bill. So according to this act, it confers absolute rights to the farmer for negotiation with sellers from the state and outside the state. So interstate and intrastate sale of farm produce is offered to the farmers by virtue of the provisions of this act. The main feature of the act is that presently the farmer can go for offering his produce to a wider spectrum of purchases within the state and outside the state. The APMC laws, which put an embargo on this freedom, has been nullified by the provisions of the present Act. Now, there are two entities under the Act, the farmers and the purchasers. The purchasers can be a person, a cooperative society, a limited liability company, a company, and also self-help groups. The self-help groups or all other persons which I have already mentioned who act as purchasers of farm produce can directly negotiate with the farmer, and he can be offered the better prices considering the prevailing rates in the country. So as a result of which, the farmer is getting the minimum not the minimum support but support price, but the price which he actually is entitled to as per the prevailing market index. For example, we have in Kerala cooperative societies which are manning a large number of consumer federations. And in the state of Kerala, there is a consumer federation also that is existing. And they are purchasing commodities from outside and at subsidized rates, making available to the consumers in the state. So the purchase by the Consumer Federation of Kerala or other consumer societies is not directly from the farmers outside Kerala. The purchase is from the APMCs which are functioning in the other states. So the price that is offered, for example, as I said earlier, take the case of apple. Present at some times the price of apple that is prevailing in the state of Kerala is 100 to 150. That is a rate that is prevailing on much of the times. Which we can understand that this apple is purchased from the place where it is grown, mostly from Himachal Pradesh or from Jammu and Kashmir. And some newspaper reports suggest that the apple producers, the farmers, are offered a very little amount, a paltry amount for the produce of apple there, 20, 25 or 30 rupees. The intermediaries, the middlemen, they are purchasing it. They negotiate with the actual purchasers outside the state. And the actual purchases outside the state, like the Consumer Federation of Kerala or some merchants in Kerala, they may purchase it for 80 or 90 rupees, whereas the farmer is paid only 10 or 15 or 20 rupees. Here, when it comes to the consumers, the price 140 rupees. So the difference, the huge difference in the price which exists at the farm gate to the markets of the consumers is being swallowed by the intermediaries. So the consumer is not benefited out of this. The producer of the farm produce is not benefited out of this. Then who is taking this? The intermediaries or middlemen are taking this. The huge profit of the blood and perspiration of the farmers. That is what is happening. This harrowing situation is sought to be avoided by the Act Free Trade, Freedom of Trade for the Farmers Bill. The freedom of trade of farmers that is ensured by the bill will ameliorate definitely the plight of the farmers of the country. And one of the main features is that as far as the payment of the price is concerned, even the APMCs are postponing the payment of price to the the farmers. The middlemen are not even paying this amount properly to the farmers. As per the present act, purchaser who is coming from another state or from the state itself, when he is purchasing this produce, farm produce, he has to make payment to the amount then and there or within a maximum period of 3 days. So the payment to the farmers is ensured by the provisions of the Act. The Act clearly says that the payment has to be done then and there or within a maximum period of 3 working days. Then it also affords creation of electronic platform for trading and transactions. The creation of electronic platforms for trading and transactions also would enable the farmers to fetch better prices for their produce. What happens in this process is that we all know the Amazon and other big players like Flipkart, they also can join in this competition. And in this process, various corporates and also other online trading companies all can join in the competition, and in the competition the beneficiary would be the farmers. So in this process, the farmers are going to benefit out of the provisions of the Freedom of Trade Bill, which ensures liberty to the farmers as far as trade of their produce is concerned. Then the other important aspect of this act is, in the states where APMCs are functioning, a market fee is being levied in the way of cess, tax, etc., etc. And according to one statistics, the government procurement of wheat and rice, which is taking place in the state of Punjab and Haryana, the Food Corporation of India is making payment of an amount of more than 8,000 crores by way of market fees in compliance with the provisions of the APMC laws prevailing there. The tax that is levied is 8.5% on the agriculture produce or farm produce, which brings in a whopping figure of 8,665 to the state exchequer. That is how the states of Punjab and Haryana are more worried about the outcome of the laws. Section 6 of the Freedom of Trade, which according to me, that's for brevity I say that this Freedom of Trade Act of the farmers. According to Section 6, this levying of fees has been taken away. Whatever contained in the state APMC laws will not affect the purchase of commodities directly through the farmers. The APMCs are prohibited from levying any kind of fees. So this is to ensure that free trade and level playing field for farmers and other new players which are intended by the Act, and also the present dominant player, that is the APMC. So what I said earlier is relating to the imposition of tax of 8.5% in state of Haryana and state of Punjab. There is a common law that is prevailing there, that is of the year 1963 of Agriculture Produce Marketing Committees Act. Out of this 8.5%, 3% will go to the market as market fees. 3% will go as rural development fund. Then the remaining 2.5% will go to the commission agents. So when 8.5% tax is imposed on government procurement of rice and wheat, out of the 8,625 crores rupees, more than 2,000 crores will go to the kitty of the intermediaries or arthyas or the middlemen. So the middlemen are naturally worried about the outcome of or the impact of the law. So naturally they are on the streets in the guise of farmers and mostly in the case of small scale and large medium marginal farmers. This is what is happening presently according to my perception of the events. So section 6 of the act is coming as a big blow to the middlemen and the APMCs who were levying a heavy fee of rupees 8.5% on the agricultural produce which are sold in the APMCs. Another boon that comes to the farmers by virtue of the provisions of this act is the crop insurance that is offered in section 9 of the act. Section 9 of the act says a farming agreement may be linked with insurance or credit instrument under any scheme of the central government or the state government or any financial service provider to ensure risk mitigation and flow of credit to farmer or sponsor or both. In short, what it conceives is the farming agreement can be made the basis for facilitating cash flow to the hands of the farmers or the sponsors, and the crop also can be insured by making use of the farm agreement. That is the important aspect of section 9 of this act. Yet another feature of the act, that is Freedom of Trade Act, is that it ensures a speedy mechanism for dispute resolution. Suppose if there is a dispute arising in between the farmer and the purchaser of the farm produce regarding payment of the amount, etc., etc., a mechanism is provided under the act. That is, the authority that is constituted under the act is the subdivisional magistrate who is competent to decide on the disputes arising between farmer and the purchaser. So what is intended by the act is a speedy dispute resolution mechanism whereby a conciliation board is conceived to be constituted by the subdivisional magistrate. The subdivisional magistrate can constitute a conciliation board for dispute resolution between the farmer and the purchaser. The committee shall compose of a maximum of 4 and a minimum of 2 members nominated by either side, and also a chairman nominated by the subdivisional magistrate. So it ensures a speedy dispute resolution mechanism. Otherwise, if the farmer or the purchaser, if they are driven to the courts or ordinary civil court mechanism, we all know the delay that is confronted by the parties to the litigation there. So it may take years for the dispute resolution, which will ultimately prove to be counterproductive to the very intendment of the act itself. The second bill is the Farmers Empowerment and Protection Agreement on Price Assurance and Farm Services Bill 2020. So which we will call the bill for brevity as Price Assurance and Contract Farming Bill. The Price Assurance and Contract Farming Bill, that is the second bill, that is I will call it very shortly as Price Assurance Bill. So this is an act which has also created many debatable issues based on MSP. So this is a case wherein, or this is the act which in fact assures a price for the commodity at the time of farming operation itself. The act envisages the conclusion of a contract between the farmer and a sponsor for carrying out cultivation in the farmland. The act says that a farmer is free to enter into a written contract with a sponsor whereby the sponsor is agreeing to purchase the farm produce at a specified rate, and the sponsor also offers farm services to the farmers. This is the essence of this agreement. So price predictability is assured by the provisions of the Price Assurance Bill and the Contract Farming Bill. The Act envisages a contract farming with price predictability. That is the important feature of this Act. The farmer is free to enter into contract with a sponsor. A sponsor can be an individual, a cooperative society, limited liability partnership, and self-help groups, and a corporate. So these are the entities which are free to enter into contract with the farmer. In the agreement, the price is also fixed. The parties, that is a farmer and the sponsor, can agree on the price of the commodity or price of the produce which is going to be reared. So this is the basic feature of this act. So here is the question of MSP and the price assurance comes. See, when there is a price assurance by way of an agreement, much in advance of the starting of the cultivation, I think that would be better than the MSP system that is prevailing across the country. Whatever it be, the government have already assured to the farmers that they are not going to dispense with the minimum support price or the floor price system followed by the governments for quite a long time. So the system of MSP will prevail. In spite of the MSP system that is prevailing, the farmers are now given the freedom to enter into farming contracts with the price predictability ensured by the sponsors. That's the main feature of this. How does it affect the rights of the farmers, or how it is going to be detrimental to the interest of the farmers? We are not able to understand. At the same time, some quarters raise an apprehension that this is an indirect way of grabbing the land of farmers by way of some secret clauses in the agreement. But the provisions of the Act, which clearly says that the agreement which a farmer is going to enter into with the sponsor must be in writing. And the provisions in the Act, that's a price assurance bill, that makes it very clear that the central government shall from time to time frame guidelines regarding the execution of the agreements, regarding the terms of the agreement, etc., etc. And the model agreement also shall be floated by the central government. So the room for exploitation or indirect play by corporates, or for that matter any person, to a great extent can be avoided by the periodical revision of terms of agreements and also the framing of guidelines by the central government from time to time. So enough provisions are there in the statutes which ensures or rather protect the interest of the farmers. The agreement should be in writing. Agreement should be on a fixed format framed by the central government. Next, another apprehension that is aired by some quarters, some sections of the agitating farmers, is that there is a possibility of corporate intervention on the proprietary rights of farmers by incorporating some insidious terms in the agreement. I think that the provisions contained in the Act itself protects or rule out the possibility of such clauses being incorporated in the farm agreements. The main provision in the Act, that is Price Assurance and Contract Farming Act, is that no farming agreement shall be entered into for the purpose of any transfer, including sale, lease and mortgage of the land or premises of the farmer. Section 8 of the Price Assurance and Contract Farming Act very clearly declares. So there is no scope for a corporate to intermeddle with the proprietary right of farmers when they are entering into farming agreements for rearing agricultural produce. Any clause which would contain or which would have the remote possibility of terming it as an agreement for sale or lease or whatever kind of indirect invasion of proprietary right is prohibited under Section 8. So Section 8 of the Act that insulates the proprietary right of a farmer in respect of his land. Yet another feature of this Act is that if a dispute arises between a farmer and a sponsor, the terms used in the Act are farmer and sponsor. In such an event, the parties can approach the subdivisional magistrate as the dispute resolution authority. The dispute resolution authority is subdivisional magistrate. If there is a clause for appointment of conciliation officers, or if there is a clause for any kind of negotiations, that has to be given first preference by the subdivisional magistrate. The Act so enjoins. And if a resolution of the dispute between the farmer and the sponsor is not coming to an end with a memorandum of settlement within 30 days, then the subdivisional magistrate himself can adjudicate. In the adjudication process, if a decree, an order is passed against the farmer by the subdivisional magistrate, that order is deemed to be a decree, but the Act very clearly says that that decree cannot be enforced against the agricultural land of the farmer. So in two ways the Act protects the proprietary rights of farmers. There cannot be any clause by way of sale, mortgage or lease in the farming agreement whereby the sponsor can create any such right in respect of the farmer's land. And further, when an adjudication takes place and if an order is passed for recovery of money from the farmer in the dispute, that also cannot be enforced against the agricultural land of the farmer. So the apprehension so aired in the media and also expressed by some sections of the farmers can have no basis at all when we analyze Section 8 of the Act and also the provision relating to the enforcement of decrees passed against the farmers. The agitators mainly attack against the disbanding of MSP system. But the Prime Minister has time and again reiterated that the government are not going to disband with the MSP system. When we go through the provisions of the Act, we can see that there is inbuilt mechanism in the Act itself ensuring a minimum support price, even though there are no government executive orders to that effect. But here is a case where the government would say that they would fix the MSP by taking into account the price variations in the market, and that system is not going to be disbanded. But let us see Section 5 of the Act itself. Section 5 of the Price Assurance and Contract Farming Act that clearly says about or gives indication about a minimum support price, which is in the form of a different phraseology that is used, guaranteed price. The Price Assurance Bill gives freedom to the farmer to enter into contracts with sponsors for farming on price predictability. Price can be fixed at the time of entering into the contract itself. And Section 5 of the Act clearly says the provision for price of the farm produce can be fixed in the agreement itself. And it further says there must be a guaranteed price for the farm produce. The agreement should include a guaranteed price. That guaranteed price is having further reference to the price that is prevailing in the APMCs or electronic trading and transaction platform or other government recognized agencies. The price reference prevailing in the APMC is nothing but the minimum support price that is fixed by the government as per executive orders. So when we see the provisions of the Act which ensure guaranteed price in the farming itself, in the farming contract itself being included, the reference is to the minimum support price that is prevailing in the APMC. The Section 5 of the Act itself says, in addition to the guaranteed price, additional amounts by way of bonus with a specific price reference prevailing in the APMCs shall be followed. That means that even in the absence of a specific provision providing for minimum support price or floor price, the guaranteed price mentioned in Section 5 of the Act ensures a minimum floor price for the farm produce. But it would be more convenient and useful, as suggested by some farmer organizations, the provision for MSP and its mechanism for determination, etc., has to be incorporated in the Act itself. I think that to a great extent, the apprehension of the farmers can be allayed if institutionalization by way of a legislation is done in respect of minimum support price. A provision can be incorporated in the Act itself, creating an authority for fixation of MSP and the various parameters and yardsticks to be taken into account by the authority for fixation of MSP. In 1990, with globalization, we opened our markets, but that was only confining to the industries. But with these legislations, I would say that revolutionary legislations which are bringing in fundamental changes in the farming sector, our agriculture sector also would be opened. What is conceived in future is agro-business. The country is going to prosper on the bedrock of these legislations. It is going to usher in a new era as far as the farming sector is concerned and the agriculture community in India is concerned. As a result of the fundamental changes which are going to take place based on or taking life from these two revolutionary legislations, the market would become expanded with increased products. So the farm produce will have to be stored. The present laws governing stock of farm produce or foodstuffs would naturally come in the way of catering to the needs of the farmers community in the wake of increased productions. So it necessitates changes in the Essential Commodities Act also. We all know that the Essential Commodities Act sets stock limits regarding the storage of foodstuffs and other essential commodities. When there is increased production, various players will come on the farm sector for storage of these farm produces. The farm produces are not meant for domestic consumption alone. The big players will also aim at exports. So naturally the farm produce will have to be kept in silos or some other warehousing areas. So the stock limit regulations in the way of Essential Commodities Act would come as a natural blockade to the revolutions or the reforms aimed by these two statutes. So as a natural corollary, the amendments also will have to be carried out in the Essential Commodities Act. A deregulation of stock limits has to be carried out for proper implementation of the two acts and also for reaping the harvest, in fact, based on the revolutions. Section 1A has been introduced in the Essential Commodities Act, which empower the central government to bring in a regulation in the stock limits only on specified contingencies like war, famine, extraordinary price rise, and natural calamity. So only when natural calamity or extraordinary price rise takes place, or in the event of war or famine, the central government can regulate the stock limits in respect of foodstuffs. But it is not taking away the right of or the power of the central government for regulating stocks completely. It says that the Act, Section 1A of Essential Commodities Amendment Act says that when there is a 100% rise in the price of horticulture and there is a 50% price rise, retail price rise in the case of non-perishable foodstuffs for the last 12 months, then the central government can bring in orders regulating the stock limits. It is not as we apprehend that the power of the central government for regulation of stock limit is taken away completely. No doubt these laws are revolutionary. It is going to fundamentally change the farming sector in India. There may be many flaws and faults or flip sides for the legislation. But we can't question the bona fides of the legislation. Present need of the hour is let the legislation take place, and from trial and error we should mold the legislation, remold the legislation, we should amend the legislation to make it a comprehensive one which would ultimately emerge as a panacea for the farmers community as a whole.